Matter of Samuel Small. Go ahead, counsel. You want any rebuttal time?
5 minutes, please.
5 minutes. Go ahead.
Okay. So it's still me, even though Mr. Loeb's name is on the brief. I think the district attorney who presented this case in the grand jury knew that notice was in order here.
Why is notice in order? Where does it say you have to have notice, and if so, how much?
Well, 190.55 entitles us to reasonable notice, and the reason that my client was entitled to notice here was that he was in effect arrested at Rikers on these charges.
Had he been arraigned?
There was never an arraignment.
Isn't
but
that the key? You have to measure the 5 days from something, don't you?
Well, the 5 days to make the motion?
Or the notice that you can appear. Don't they have to give you notice that you can appear in front of the grand jury within a certain number of days after the arraignment?
Well, I think the problem is here that because there was a complaint and there was an associated arrest warrant out, which they more or less executed at Rikers, the district attorney knew that notice was in order, but the problem is they didn't do it right.
Can a CO affect an arrest?
I think that they did. Whether they're allowed to under the CPL is a separate question. But I think if you go to an inmate at Rikers and present a felony complaint and say you're being arrested on this felony complaint, you pretty much feel like you're under arrest, and I think that's a reasonable perception.
You're already in custody. So what's the nature of this arrest?
Well, the arrest is informing you that you are now in custody for an extra thing. Mm-hmm. And that extra thing has attached to it an arrest warrant which directs criminal justice, somebody, it's the police, but somebody should have done it to produce this defendant for an arraignment. But the people didn't take care of that. Instead, the presenting ADA, I think, understanding that something needed to happen, went to defense counsel in the courthouse at the grand jury, a lawyer who had only been appointed apparently that day for this defendant. He didn't have the same lawyer who had represented him on the arraignment on the other case a few days ago, and just dropped it on them.
Could he have said, well, wait a minute, I want an adjournment of this. I didn't have enough time to prepare. I mean, he certainly had noticed. You could question whether that's reasonable or not, but it seems to me that he made a choice to go in there knowing what was going to be presented and, waived immunity and went forward. No question it would have been better off if this lawyer had done that. And I think it would have been better if defense counsel, who made another new lawyer, who made the motion, the timely 190-50 motion after the Supreme Court arraignment, had fleshed this out a little bit better. But the saving grace is the trial judge's decision, which explains exactly what happened and then holds that the defendant that his right to testify in the grand jury was satisfied. The problem is that the defendant didn't see it that way.
Well, let me ask you this though: if we played it out, in other words, let's assume the second lawyer said no, don't ask him anything about the second one. You got him on the one because he's going on the first one, right? He's going to the grand jury, so he testifies on that. And then they submit the second one to a second grand jury without notice because you haven't been arraigned. Is there a problem there?
Well, there's a problem on the facts of this case because of the presence of the arrest warrant and what happened at Rikers Island.
So are you looking for a rule that says if you've been arrested, you cannot be indicted without notice?
I'm looking for a rule that says that if there's a felony complaint and there's an arrest warrant out, and beyond that, you're actually they go through motions that, while not strictly what the criminal.
No, but can we skip all that for a minute, though? I mean, let's just assume that there's a felony complaint out there. Can they indict without notice because you haven't been arraigned, they haven't found you, they're still looking for you, but they want to indict you.
The statute anticipates indictments without notice.
Right.
But what we have here is, we have more than that. We have the defendant being confronted with the complaint at Rikers Island. We have a direction in...
Isn't there another component to this, counsel? Doesn't the arraignment have to be delayed to defeat the defendant's right to go or suspect's right to go into the grand jury? And given the dates here, wasn't this assuming he was arrested, wasn't that a Friday and he was going into the grand jury on Monday? So where's the delay?
I don't think that the problem here is that that there was delay in bringing him to the grand jury. I'm not insisting on
Arraigning
a
him.
24-hour rule
Aren't you
here.
complaining that he wasn't arraigned?
That's what I'm
yeah.
complaining about.
So
I'm not.
when were they going to arraign him before they brought him to the grand jury on Monday?
I think that they probably needed to move the grand jury presentation in order to accommodate that, because they had reached the point where he was entitled to be arraigned, or they could have gone forth with the grand jury presentation but not presented both cases. I mean, that was their choice. That wasn't our choice. And that's what they weren't entitled to do, at least the way they did it, because he, in effect, was ambushed with it and didn't have reasonable notice. He didn't have adequate time to consult with his attorney, and that played out in the grand jury.
Going back to Judge Stein's question earlier, once he's told that they're going to be asking him questions in the grand jury about another crime, he went ahead with the waiver of his immunity anyway. He could have said, well, I'd like to do that another time, or I'd like some more time to consult with my lawyer. Couldn't he have said that?
Well, he more or less did that, although, you know, he could have been a little more articulate about it, but he protested quite a bit. But the ADA presenting the case basically blew it off. These minutes are in our appendix, and the defendant at the beginning and the end repeatedly complained that, you know, this had just fallen on him and he hadn't had a chance to talk with his lawyer.
Well, then don't you have an ineffective assistance argument?
Well, not so far.
Well, I mean, isn't that what really, if you're saying the ADA blew it, isn't that what this boils down to? Not, you know.
Well, I think that the various lawyers here could have done a better job, but the information's in the record, and the judge did make a finding, which I think preserves the issue for you, that he did have adequate notice and he did have his chance to testify, but it doesn't look like that to me, because he was complaining all the way through, and the ADA should have taken account of that. If it's okay, I'll turn to my
Go ahead,
my second
sure.
point. Okay. The predicate felony that was used here shouldn't have counted. The state habeas ruling that found that the division of parole just completely screwed up here, and that my client shouldn't have been subjected to incarceration on a parole violation.
Isn't that decision subject to a couple of interpretations? One is he shouldn't have been violated in the first place, and the other is it just wasn't fair to give him 18 months on these circumstances.
I don't see how the latter interpretation is possible, because I don't think that's what state habeas courts do. It seems to me that the only issue before the state habeas court was the legality of the violation. Now, it's a.
Can we second guess that? For example, if we think that it was proper to revoke his parole, for example, because, or you know, no abuse of discretion there, because you know, he failed to provide the documentation that he was asked to, and he didn't report to probation, so they had every right to violate him and to revoke him. Can we find that here?
I don't think so. That's a really fact-laden decision with a lot of judgment in it, and let me put it this way: there's no support in the record.
As a matter of law, he violated
Yes.
the provision, the conditions of his parole.
Not on these unique facts. I mean, you have a New York City detective explaining in the parole hearing exactly what happened. You have the hearing officer and then the presenter, I forget what their title is, in the hearing, all coming to the conclusion that this guy this shouldn't have. There's no violation here. He's become an informant. His life's in danger. He's doing exactly
But
what
Mr.
he
Greenberg,
said.
fundamentally, isn't the purpose of these of these exclusions is because you didn't have an opportunity to commit any crimes? So that's why it's not, it's taken out. I mean, whatever the reason, that while he was incarcerated, he didn't have any opportunity to go commit a crime. So when we
Well,
count
but
to 10,
the word reason in your Dozier decision means something, and in Dozier.
what I'm saying is if somebody had been in jail for 10 years and says, hey, I didn't commit a single crime in 10 years, of course not, you were in Attica.
Oh, but
You can't say, therefore, it can't count. And I would think this, even though, you can say he shouldn't have been, et cetera, fact of the matter was he was out of commission.
Well, that's the general philosophy of the tolling time part of the statute, but the court, and based on the language of the statute, has established a couple of situations where that doesn't work, where the prior conviction was unconstitutional, and in the case of Dozier, there was newly discovered evidence and the determination that they couldn't go forward, so it really voided, in effect, the prior conviction. In this case, to me, it's just like Dozier, because after the fact, the state habeas judge figured out that this never should have happened because he did.
What about the argument that even if you're right, you're talking about Judge Dadd's decision,
Yeah.
right? Even let's assume he's right. There still seems we're still stuck with the 15-year sentence, and couldn't you be sentenced for 15 years as a violent felony offender as well as a second felony offender here? So,
Well, it would be a
Thought he
legal
could.
sentence, but if you agree with me and he's reclassified, I think he's entitled to resentencing so that the sentencing judge can take into account the change in his status.
Okay, counsel, thanks.
thank you.
Counselor.
Good afternoon. My name is Ann Bordley, and I represent the respondent, the people of the state of New York. The trial court properly denied defendant's motion to dismiss in the interest of justice. Contrary to defendant's claim, the people did not violate the prompt arraignment rule of 120.90. On Friday, April 7th, 2006, when corrections officers approached defendant, what they were doing was lodging the warrant against defendant. They were not executing an arrest warrant. Corrections officials do not have the power to execute an arrest
So
warrant.
the defendant was wrong when he said these corrections officers approached him and handcuffed him and told him he was under arrest?
I don't think he said they told him he was under arrest. Well, he said he was formally arrested. I think that was the language in the motion. I think he's misinterpreting what they're saying. I don't know exactly how the
Well, what were
corrections
they
officers.
doing?
Well, I know, but the corrections officers do have to lodge the arrest warrant, and when they to take fingerprints to make sure he is the person who is the subject of the arrest warrant. So they took the necessary steps that they have to when they lodge an arrest warrant against someone to make sure they're holding the right person on the arrest warrant. So there is a procedure that happens.
They're holding him on an arrest warrant, but they're not arresting him.
Correct. There's a difference between executing an arrest warrant and a detention.
I wonder if that was-
Arrest means,
Before the arrest warrant is executed?
excuse me?
Does that usually happen before the arrest warrant is executed?
Yeah, well, yes, under some circumstances. We often lodge, they're called detainers. You use an arrest warrant as a detainer. You'll frequently see the situation where someone's in an out-of-state prison. Somebody's arrested in New Jersey and they're doing 30 days. We want them. We will get an arrest warrant from our judge. It will be lodged against that defendant in New Jersey. When that defendant finishes his 30-day sentence, they call us up and they say, we're about to release him. Do you want him on your arrest warrant? And we pick him up. So that's how it normally works. But when it's only when that police officer goes and executes the arrest warrant and then takes him, that's the execution.
So when he's in custody
He's in custody.
here,
He's in custody on the
here.
felony complaint.
the COs lodge this warrant.
Yes.
So you're saying he's not under arrest under that warrant?
He's being
He would only be under arrest if for some reason he's
No.
able to be released from custody?
No, Your Honor. What I'm talking about is the definition of what it means to execute the arrest warrant. When a warrant is lodged against you, you are being detained pursuant to the warrant. He was also being detained pursuant to the other felony complaint. But he was being detained in part by the warrant. And while detentions, you can use the word arrest, can have a very broad meaning and can refer to any kind of detention or seizure. Nonetheless, when we want to use it for purposes of 120.90, and we're talking about what it means to execute the warrant, the execution of the warrant comes when the police pick him up.
How long can you
How long
hold
can you
him?
be detained?
Well, the defendant's also being detained.
You're not being arrested. How long are you detained?
Well, excuse me, he's being detained also on the felony complaint. So that's why the issue didn't
Yeah,
sort of
forget
come
that,
up.
though. I mean, it seems like a very technical thing that you're,
No, Your Honor. Say, for example,
it's not technical?
well, maybe it may be technical. I will agree with you it's technical. But generally speaking, so again, take my person that's arrested in New Jersey. Once they're being held for 30 days, their 30 days expires, the New Jersey authorities can hold him briefly. I can't give you an exact time, but they will hold him briefly on the arrest warrant, call up New York authorities and say, do you want him? If you want him, come now. If you do not want him.
And then you put him under arrest.
No, then if New York says we don't want him, then they release him.
I don't know, but if New York says I want him.
Then we come and arrest him. And that's when the execution of the warrant occurs.
Okay, so in this case,
Yes. in this-
again, what?
Okay, what happens in this case? He's on the felony complaint. Say he'd been on the felony complaint, and we decided we're just going forward on that burglary which he's arrested on the street for. And so we put the evidence in the grand jury, defendant testifies, grand jury decides not to return a true bill. So he's supposed to be released. He's not going to be released because the court will issue an order saying, he should be released unless there's any hold or warrants. Corrections gets that and says, well, we do have a warrant. They call up the police department and they say, do you want to execute this warrant now? And then we would have done the circle all over again. Police officer would have taken him in. We would have arraigned him on the additional one. We could have done that procedure. It's a long
Like a little
procedure.
placeholder.
It's a
In case he's going to
placeholder.
be released, you have to hold him in case we want to come and arrest him.
Yes, but we have to come very quickly. They're not going to hold him very long. But that's all it does. It serves as a
Judge
detainer.
Islam.
Had lodged the complaint,
Yeah.
but not arrested him or arraigned him.
Yes.
Could you have presented any evidence before the grand jury
Absolutely.
on the February 06?
Yes, absolutely. We could have done that at any point in time. And that brings up an important, very important point here. What we could have done was we could have just gone in, presented that Severin burglary, the burglary where he's arrested on the street and he's been arraigned. Defendant could have testified about that. We could have not told him a word about the fact that we now had evidence linking him to another burglary. Voted out that case, then presented the Severin case directly, never had him testify, and then had the grand jury vote on it. And that's clearly lawful.
State case, the 223 case, right? That's the one that
Yeah.
didn't win. That's
Yeah.
the case you mean, yeah.
Yeah, yeah. So we can make a direct presentation when a defendant has not been
No
arraigned.
arrest, no arraignment, just go straight to the
Go
grand
straight to
jury.
grand jury, and that's what the law allows us to go do. In this case, because we knew we had the two cases, we took another option. We thought, he's going to be here on Monday, right? This is Friday. It's going to be here on Monday to testify. We will tell him, we will let him talk about both. We didn't have to, but we'll let him go and testify both. Let the grand jury hear him about both.
So why'd you tell him on Monday instead of on Friday?
There was no court proceeding on Friday, so he wasn't there. That was just the day that we issued the arrest.
Logistics?
It's partly logistics, and the fact is,
You
when
chose not to arrest and arraign, so therefore you have this logistics challenge?
we'd filed the detainer warrant we had filed the warrant as the detainer, so we're going to be there on Monday. We tell him on Monday. If the defense attorney thought he needed more time, he could have asked for an adjournment. We're required, like People v. Shemesh and a whole other lot of cases, to accommodate those kinds of requests. We have to give them sufficient time to go do that. And defense attorney in this case never made that request.
Well, let me ask you, this just occurred to me while you're talking about all this. You know, if a defendant asks to be in front of the grand jury, if you give him notice he's coming,
Yeah.
most times he's talked to his lawyer and they decided it's in his best interest.
Yes.
If you directly present it, he's not there. He
Right.
can't say it. This middle ground where on the day you're going to present it, you say to him, we're presenting it, you're going to be here anyway, you want to talk about it. There might be an awful lot that goes into I mean, then I would think the lawyer would want to say, well, wait a minute, come over here. Where were you on the 23rd of February, et cetera, et cetera, et cetera?
Yes, there could be in some cases. And again, one defense attorney can ask for.
So let me ask you about that second defense attorney, the defense attorney on the February case.
Yes.
Where'd he come from? Because he hadn't been arraigned, so he didn't. It wasn't.
Yeah, there isn't a lawyer in the second case. So there's just the first lawyer from the case he just got arraigned on, the Severin burglary.
Well, who advised him on the February one?
He's got one lawyer who's at that point is representing. Who's representing him on the one case is also representing him on the other case. So the one lawyer
Signed.
He hasn't been assigned
He'd
yet,
been
but both cases are being
Had he
presented
been?
at that point.
I know that. Had he been retained?
No, not as far as I know.
So he hadn't been assigned. He hadn't been retained. You just said, "Gee, I hear you're up for a murder. You want to come in and talk about that?"
Well,
Why
at that
don't you
point,
talk about
defendant
my
doesn't
burglary?
have an attorney on that case. But I want to make another point about this case. In
No, but
addition,
wait. I mean, I'm just curious about that
Yeah.
because I would never let my client go in front of a grand jury unless I'm pretty damn sure he's got a reason to be there. And if I decide he's going to be there on one, and then say, well, by the way, we got this murder case that we're going to present. I know you're getting ready.
I'm sorry.
Do you mind? I know you don't represent him on a murder, but since he's going to be there, we're going to send him in. Is that okay with you? Well, I have no authority. I can't say because I don't represent him on that.
First, I do think you do have the authority to go represent him in all these other kinds of issues that
says?
come up. Your Honor, in representing him on the one case, you're also giving him general
No,
representation
I'm
on the
not.
other.
Oh, absolutely, I'm not. I'm representing him on this one. I'm getting paid for it, and I'm very carefully deciding that he's going to appear in front of these people where you're going to be and I'm not, and that's fine. But to
would
say
be our-
that, well, you're representing him on that, you can represent him on the fact that he killed his wife, and we're putting that in at the same time, so. what's the
But
big
Your Honor,
deal?
the ultimate result of that is that we would never do it this way, and what we would always do is do the direct presentation. We just
And
never
wouldn't
give
that
him a
make
chance
much
to
more
testify.
sense, and then.
But I would point out that there was no prejudice to the defendant by doing this. First, there's the fact that the defendant could ask for that adjournment.
Because you would not have had to give him notice. You could have done this without.
Yeah, we could have done it without
the
him.
arraignment, without notice, so he's
Right.
not put in a worse position, and because he could have sought the adjournment.
Yes, he could have
and
sought the adjournment.
avoided what he claims now is what causes him prejudice.
Yes, and when you look at actually this particular case, in this particular case, the defense attorney didn't need additional time because of the defendant's defense in this case. Defendant's defense in this case didn't involve a discussion of the facts of the individual burglaries. His defense, for one, was the same as his defense as the other. His defense was, I didn't commit any burglaries. And he says, I don't have a motive to commit burglaries because my family has money. And the reason why I'm being accused of burglary is because the police have a vendetta against me because I sued them civilly and I got a settlement and because I didn't cooperate in
Well,
investigation.
he might also have some other defense, right, in addition to that one, that maybe
No.
only applies to the other.
No, they both did, and
I
we know that.
understand, but let's go with the hypothetical. It's possible.
Yes, but we
Defendant
know what,
may have something else they would have shared.
then they should have asked for the adjournment. Defense counsel should have asked for the adjournment.
I understand your
Yes.
position.
He didn't have a lawyer.
But I would point out, defendant did testify at trial.
Okay.
And at trial, his defense was the same in the grand jury.
Ms.
which is just this-
Ms. Bordley, I understand. What I'm suggesting, though, is if he didn't have a lawyer on that second one, you say his defense would have been the same.
Yeah.
Maybe he had an alibi. Maybe he was in Canada when the allegations are made, and no one had an opportunity to prepare for that. And if you're telling me that because I represent him on the first one, I'm representing him on the second one, and I said fine, and I throw him to the wolves, I'm not sure I should be doing that.
No, Your Honor, I'm not saying you throw him to the wolves, and certainly not in this case. Again, at his defense in the case, they didn't raise alibi. He's got a different attorney at that point.
I'm going to leave you alone after this. I understand that on this case. I'm
Yeah.
worried about the next one.
Okay. But then I would bring up, this is being raised not in the context of a 19050 motion, because his 19050 motion wasn't on this ground. This was being raised in the context of a motion to dismiss in the interest of justice on the theory that this was such exceptionally serious misconduct by the people that it warranted the termination of this prosecution for 2 burglaries. And even if you think we made a mistake here, where we tried to give defendant an opportunity to testify, when we didn't have to, but we tried to give him the benefit of testifying, and we could have given that defense
Is there any
attorney.
basis by which, if he had sought, if on that day
Yeah.
he sought the adjournment, is there any basis by which he would not have gotten an adjournment?
I can't think of one, Your Honor.
Can I just ask on the motions? I thought there were 4 motions to dismiss. Three.
There's
There's three motions to dismiss. The
There's three
first
that are
was a
issuing
one-
appeal.
It was a 190-50, wasn't it? Or it was 210-20?
The first one was at 190.50, but it was on a very narrow ground. It's not the ground that it then shifted to. The first ground was, I was completely ambushed. They started asking me questions about this. They gave me no warning. The judge looks at that and says, the grand jury minutes showed they did warn you before the grand jury presentation. He didn't say, I didn't get enough notice. That doesn't come up.
Didn't he say that? Didn't he say he didn't have a proper time to prepare?
Not in his 190.50 motion, which was very narrow. He said we completely ambushed him, we never gave him any notice. And that's what the judge decides, says, no, you did have notice. And then defense counsel then, and so when that gets denied, a year and like 11 months later, they make a motion to dismiss in the interest of justice. And now they're raising he didn't get enough notice, and that's serious misconduct. He's raising a 190.50 motion in the middle of a motion to dismiss in the interest
Your
of
light
justice.
is on, so could you address the second point about
Yes.
the resentencing?
Yes, Your Honor.
Can I ask you one question about that, which is, if it's a habeas corpus proceeding,
Yeah.
what other basis could there be to release him other than that his incarceration was not legal?
The basis is supposed to be that his incarceration was not legal, but I don't think that's the ruling the court made in this case. I think the language of the court very specifically said the evidence did not support the imposition of 8 months continued incarceration. By saying, he's saying it didn't support 18 months incarceration. He didn't say it didn't support any incarceration. He did not vacate the parole warrant. So I think the habeas court exceeded its authority when it issued this writ of habeas corpus. But I think the more important point is I think this court is not bound by what the habeas court said. And in Dozier, you said you only you exclude any kind of incarceration except if the incarceration has no reason. There was a very good reason.
Didn't the court say that this incarceration, that the defendant was in prison without reason?
There were very strong reasons for his incarceration in this case. He stopped reporting to his parole officer. The most basic, the most fundamental thing that a parolee must do is stay in contact and meet with his parole officer. He stopped doing that. He did not report a change in his residence. And what's significant is some of the details about that. What he told his parole officer the last time he talked to him was that he was in protective custody. The parole officer said, send me documentation of that. Defendant doesn't send the documentation, and there's a good reason, because he's not in protective custody. You know, I'm sure the parole officer thought he was in a safe house with law enforcement. He wasn't.
Counsel, okay, thank you. Counsel Rebuttal.
Here's how bad the division of parole was here. The detective testified that he informed 2 parole officers about what was going on here. One of them was the one who signed the, whatever the document is that lodges the charges. So that, and they didn't bother to call that parole officer to help sort this out at the habeas hearing. So the detective made clear he was in touch directly with the parole officer, who then turns around and accuses my client of not fulfilling his obligations. The detective sorted this all out. They had no basis for violating this guy, and that's why the time shouldn't be counted at all. It's a very fact-laden decision, so there may be an implication, well, it's almost a little like a time cut. It's not. It's a finding that they had no basis.
Counsel made reference to that he was not in protective custody. Can you address that?
I think that's just a term of art here. You know, all things being equal, it would have been better if the detective, who really was the one doing the communicating, he did explain to them what was going on. It just, as I said,
He relocated to his friend's house in another place at the advice of the detective after being shot 7 times.
Well, it wasn't just on the advice. I mean, the record, as spelled out in the decision, shows that the detective was shuttling him back and forth to Brooklyn pursuant to his cooperation agreement. Law enforcement was on top of this, but for some reason...
I got the impression, though, that the judge that ruled in his favor, it was more because he thought the sentence was excessive than that there shouldn't have been a sentence at all.
I don't think you can read it that way. I don't think you should read it that way. I don't think the habeas court has the power to find a sentence excessive. That's not what habeas courts do. And even though it's fact-laden and it explains the whole saga, I think the ultimate finding is that he shouldn't have been subjected to this violation because he didn't do anything wrong. I mean,
He
the little-
said whoever imposed the sentence didn't consider the ALJ's recommendation, which would have prescribed a significantly lower sentence.
Well, he also says that they had ignored all the evidence, and the evidence showed that he didn't do anything that warranted being violated at all.
Okay, Counsel. Thanks, thank you both.